My lord, with your leave, may I be allowed to mention one matter? My lord, may I be allowed to mention one matter with your leave? I could hear nothing, my lord. My lady, may I be allowed to mention one matter? The urgency is my lord be able to hear me? My my lord, is my lord able to hear me, my lord? My lord, is my lord able to hear me? My lord, there is an urgent matter. My lord, is my lord able to hear me? My lord, there is an urgent matter. My lord, is my lord able to hear me? My lord, the urgency is, my lord, that a minor child life is dependent on this matter of CRA 21, my lord. Lastly, it was listed to be by Justice Ghosh to be listed on 11, my lord. My lord may take up this application because the life of a minor child is dependent on this, who has been unlawfully detained by the matrimonial uncle and the matrimonial grandmother, and the petitioner is the father. The detention happened after the demise of the mother of the minor child, my lord. My lord, please pardon me, my lord. I could not hear, my lord, anything from my lady. Pardon me, my lady. Kindly keeps this matter, my lady. Kindly keeps this matter, my lord. At least it could be taken up, my lady. I'm still unable to hear, my lady. Is my lady heard me? Has my lady heard me? At least keeps this matter, my lord, at least in a position where it could be taken up tomorrow, my lord, my lady. And it has been it has been sent back from Honorable Supreme Court, my lady. The petitioner has traveled to Honorable Supreme Court even.
My lord.
Your lordship
Not
has
in a bail
considered.
application.
Your lordship has considered this in a bail application. My lord, I will place that, my lord. Kindly, my lord, takes up paragraph 21. For once, my lord, I will not take much time.
20.
21, my lord.
Yes, 21.
Conscious possession refers to a scenario where an individual not only physically possesses narcotic drugs or psychotropic substance, but is also aware of its presence in nature. In other words, it requires both physical control and mental awareness. This concept has evolved primarily through judicial interpretation
Yes,
since
how
the
will this be
now, my lord,
determined?
this has been reiterated by this honorable court, my lord. Let me place, my lord. My lord, kindly takes. দিচ্ছি দাদা হরদীপ সিংটা দেখুন
You give me 2 copies.
yes
To the
oh
Shine.
my lord I'm so sorry my lord so sorry my lord my lord in this matter my lord this Rakesh Kumar Raghuvanshi and paragraph 21 of Rakesh Kumar Raghuvanshi was considered and my lord on this count my lord
Judgments are relied upon.
yes sir my lord also again considering this factor my lord again my lord 300
I'm sorry, but this
30
shows whether what was considered and how it was considered.
my lord kindly
That is
takes
not-
kindly takes up
Only
this
one line
yes this has
different
been
features, my lord.
reiterated here my
Rakesh
lord
Kumar Raghuvanshi
Let him
is
complete.
totally
this has been
Let him complete.
reiterated here my lord kindly takes it up my lord how it has been
He's
reiterated
trying his best, let him.
My lord, my lord.
my lord this matter is CRM NDPS 151 here my lord
Yes.
the concept that the contraband was kept in dicky this matter was considered
Same thing. In the other matter
yes my lord
also
but
the same thing.
but in
Yes.
detail this has been considered kindly takes up paragraph 7 my lord of this judgment my lord how this has been considered
Again, this judgment refers to criminal appeal.
yes my lord
This is matter of
this is of
evidence,
appeal
sir, I
but this
repeat.
is a matter of bail
This
my
is a
lord
matter of evidence.
but this
In a bail application, whether it's conscious
my
or
lord,
not cannot be
but my
considered.
lord the judgment of Rohit Patel that I have served my lord that is a bail application my lord this criminal appeal matter was considered there my lord my lord I can only try my lord but your lordship kindly sees one scooty's dicky contraband is being seized my lord I'm not the owner of that
Rakesh
scooty
Raghuvanshi is an appeal.
yes my lord
So
that was considered in
evidence.
Rohit Patel which is a bail application my
There
lord.
was evidence.
Yes, my lord, but that was considered in a bail application in Rohit Patel, also in Hardeep Singh. I have submitted, my lord, before your lordship. Those two judgments has been
Rohit
delayed.
Patel.
Yes, my lord, Rohit Patel, CRM NDPS 151 of 2025, my lord. Could your lordship find it, my lord?
Coordinate bench's judgment.
It's a paragraph 7, my lord, kindly consider.
With utmost respect, I say these are persuasive.
Yes, my lord,
Right?
that's the best I can do, my lord. I can try from my end, my lord. But kindly considers if a contraband is kept in a dicky of a scooty, and my lord, I'm not the owner of the scooty.
Let me hear the
The
state. Let's
police,
see
my
what
lord,
evidence
one
has
last
come.
submission, my lord, one last submission. My lord, I'm not the owner of the scooty. To implicate me in this case, they must have indicated some meeting of minds with me and the other accused person who is the owner of that scooty or who was again apprehended with me, any CDR or anything of that sort, my lord, if there was anything like that. My lord, that's the question I asked to myself, my lord.
Let me ask. Yes.
My lord,
I'm so great.
Yes.
25 bottles of cough syrup, my lord. This was seized from the present petitioner, my lord. The scooty carrying the contraband articles dicky of the scooty, my lord, he is standing the spot, my lord. And my lord, the arrest memo as well as
Does
the
he have any connection, any nexus with either the scooty or the material?
my lord,
There may be a lot of people who are standing at the spot, on the spot. What is his connection? How have you connected him?
my lord, this is the ground of arrest, my lord.
No, how have you connected him with the contraband?
But he's on the scooty, my lord.
You have just said that he was standing near the scooty.
Yes. I'm
কমপ্লেটে আছে তো আমি তো স্কুটি চালাচ্ছি কিছুই না I was a bystander in this.
Was he either the driver or the pillion rider?
Two male persons, my lord.
Both the persons.
Both the
from
person,
whom
my
the
lord.
recovery was affected. Both were standing together. But they were standing there for the purpose of delivering the contraband
Contraband.
to the prospective receiver of the contraband. Both of them were standing at the same time at the same place together. So there are connections with the co-accused persons. They are peddlers who were there to deliver the drug. This is the connection. Grounds of arrest has been supplied to them. Proper grounds has been written. Why they have been arrested.
No, he's not on grounds at all. The nexus,
Yes.
the connection.
Next is
Yes.
conscious possession, as my learned friend is saying. He is relying on Rakesh Kumar Raghuvanshi. What the Honorable Supreme Court has said in Rakesh Kumar Raghuvanshi, that conscious possession is something which the court has to keep in mind while trying a person.
I've
under
already
the
said that.
indication.
That has to be determined.
But
Yes.
at the same time, conscious possession is such a thing which the accused person has to show that he was not in conscious possession. It is not on the prosecution. That is what the Rakesh Kumar Raghuvanshi has
Where
said.
is the season list?
Yes, my lord. Page 16, my lord. 16, 1-6, my lord.
1-6 is memo of arrest.
Season, my lord. My lord. Caesar. My lord, may I? Yes, very my lord.
He is Rudra Prakash.
Rudra
Prakash.
From the joint position of both the persons, my lord.
And the independent witness also there, my lord.
Where is the independent witnesses?
Signature, my lord.
In the memo of arrest. Sorry,
In the Caesar list, my lord.
Not at this, sir. I'm sorry.
But my lord, only 25 bottles. Till 30 bottles it is
Only
allowed.
25
Only
bottles.
No, my lord. Earlier, my lord, it was 100 bottles. Then it has been 10 bottles regarding the containment
25
of the
bottles is
coating.
commercial quantity or not?
Yes, my lord, it is commercial quantity. But my lord, earlier, my lord, till 30 bottles it was considered, my lord. If your lordship
So
would
you
kindly
have to go
consider.
back to the earlier judge then, sir, not this court.
My
NDPS
lord,
is a
200
serious
days in
issue.
custody
No,
also
no.
is there, my lord.
How many days?
200 days.
37, you've not been able to rebut.
No, my lord.
co-accused
The-
person's bail has been rejected.
The
My lord, trial also
petitioner
cannot
is
be
in
proceeded with.
custody. Charge sheet submitted?
Yes, my
My
lord.
lord, charge sheet. Just
Trial has
trial-
commenced?
Trial cannot commence, my lord.
Submitted, my lord.
Just,
lord,
my lord.
yes,
This is
sir.
2025.
My lord,
news, my
co-accused
lord.
is absconding, my lord. Trial cannot commence, my lord. Kindly
26
consider.
June, you've been taken into custody.
Yes, 26 July, my lord.
26 July. You've stated
27th
June.
July, my lord.
Yes, 27 July.
27th of July, my lord. I have been taken into
So you
custody.
say more than 6 months.
Yes, my lord.
The petitioner is in custody for more than 6 months and prays for bail. Learned counsel for the petitioner submits that the petitioner was merely standing near the scooty from where the contraband article was recovered. He has no nexus whatsoever with the article and cannot be said to be in conscious possession of the same. Charge sheet has been submitted. Trial is yet to commence. Stop here. His further detention is not required. Learned counsel has placed reliance on orders of coordinate benches of this court, as well as the order of the Honorable Supreme Court in Criminal Appeal number 1953 of 2014 in support of his contention. Paragraph vehemently opposing the prayer, learned counsel for the state submits that contraband articles of more than commercial quantity were seized from the conscious possession of the petitioner and the co-accused. Stop. Investigation has been completed. Trial shall commence shortly.
Lord,
Fine.
charge sheet submitted
I
without
have
FSL
considered
report, my
the
lord.
material on record. The Honorable Supreme Court, in the authority referred to by the petitioner, has dealt with the concept of conscious possession inverted comma rakham in an appeal
That was a bail application. That was a bail application, but ultimately the bail was denied by the Supreme. After elaborately discussing conscious possession, it was.
কি বললাম ওটা বলুন কি বললাম no, again, has dealt with the concept of conscious possession and has observed that conscious possession implies that the person knew that he had the illicit drug or psychotropic substance in his control and had the intent or knowledge of its illegal nature. Stop. Whether the petitioner was in conscious possession of the contraband article has to be determined at the appropriate stage of trial. In view of the fact that contraband article of more than commercial quantity was recovered from the joint possession of the petitioner and another, the petitioner has failed to rebut the restriction laid down under Section 37 of the NDPS Act and does not deserve to be released on bail at this stage. Paragraph. Accordingly, prayer for bail is rejected at this stage.
Great.
CRM disposed of, urgency to the website copy. Sorry, sir, I have to start with a rejection. Next.
So item number 10,
Item
praying for
number
only
two.
not today, my lord.
Not today, 2 and 3. Very
2
well.
and 3.
Not today.
Item 4,
Also for item number 4, I am praying for not this week as the conducting advocate is out of station also. Jump up.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on next week. You want to come back?
Monday also.
16th? On 16th February 2026. Next.
No, item 5 and 6, I'm bringing one day accommodation. Madam for the state, your lordship. I'm holding the seating. Not today.
Not today. Observations will not change. Even
no,
if
no,
there is a
no,
not today. I understand why you're taking a not today.
No.
Please do that.
Well, if your lordship kindly have a look at the last order. Tomorrow.
There
I
was
am doing
a- he
tomorrow.
wants to
There
come
was a
back
specific
tomorrow.
direction. Today is the No first day, adjournment will be tomorrow. allowed.
He wants to come back tomorrow. Let him.
item 7,
My lord, I am appearing on behalf
My
of the
lord, I am
state in this
petitioner, my
matter.
lord, I am praying for not press this application. My lord.
Learned
My lord,
counsel-
I also have a submission here, my
Yes.
lord. I want to return this brief because I returned this.
He's not pressing.
Yes,
Learned counsel for the petitioner submits that the petitioner does not intend to proceed with the application. Paragraph in view of the above, the application is dismissed for non-prosecution.
Not-
Urgent help at website. Next.
item 8,
Item 8, anyone?
my lord, I am for the state.
Well, I'll not dismiss on the first day. From tomorrow, I'll start my dismissals.
Fine.
Not today. Next.
item 9,
My lord, I am for the petitioner. My lord, in from item 9 to 12, my lord, they are running serially. My lord, kindly give 1 day accommodation to, my lord. The
If all
matter
the
is-
matters are given 1 day accommodation, that means you're not interested in the bail.
No, my lord, no, my lord. That's not, my lord.
Please make your submission.
My lord, kindly, my lord, 1 day accommodation may be given, my lord.
Come back next week. Everything cannot be done for a day. I have to deal with other matters also. I have a long list.
But huge quantity, commercial quantity.
Not today. Till 12.
Till 12, my lord. Well,
Next.
13, Lordship, I'm praying for short pass over.
Not possible. Make your submission, please.
Lordship, my senior is in court number 1. Kindly short pass over, Lordship.
After that, you have to come back after the 275 matters that are there in my list, right? Not today. Not
then not
today. Come back tomorrow. Not today.
14,
I'm for the state lordship.
Petitioner?
My lord, I'm praying for not this week. Yesterday, the charge sheet has been delivered to the petitioner.
Very well. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 17th.
Get first.
Next. 15.
My lord, for item 59, bring 1 day accommodation, my lord. For
But
item
let it be
59.
not this week because we have returned the case diary. It was required in the
You
trial.
want to get it back. Very well.
Yes.
Next week, Monday.
1 day, man.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 16th.
Grateful, man.
Next.
My lord,
16.
I'm on behalf of the petitioner lordship. This is NDPS case lordship. This is, in this case lordship, the article,
Who is appearing for the state?
I am appearing for the state.
Yes.
article found in this case lordship, below commercial quantity lordship, one co-accused person granted bail lordship. And
Below
charge sheet has
commercial
been,
quantity?
yes, lordship, 14.33 kgs of ganja lordship.
কি বলছে?
This is the 16, 16.
তো ভুল হচ্ছে আমাদের মামলা না।
Where is the Caesar?
Lord, my lord,
Have you annexed the Caesar
there is
list?
some problem, Lord. We have somehow misplaced the document because case document has been misplaced. I am holding a different case diary due to shifting, Lord. May I get 1 day's time, Lord? Because the names were similar, my lord. So different matter, different case diary has been.
Charge sheet has-
Very well. Let him come back tomorrow. Prince lordship. Not today.
Great. Lord, can it be passed over, my lord? Because CD is there, I will file. Let it be passed over 2 p.m. We'll do it.
Very well. Grateful. 2 p.m. Rahul. Since the petitioner is ready, let it be 2 p.m. Next. 17.
My lord, in item number 17, 1 day accommodation can be given. My lord, I will be prepared tomorrow because today is the first day. So in many cases,
Don't want any rejection so far now.
no, my lord, not like that, lord.
And I have
Commercial
started
quantity.
with a bomb blast. So
That's the
No, my lord, it is in the least lordship. We have to do.
absolutely. So do.
No, my lord, I'm not prepared for today, lordship, kindly tomorrow.
Not today.
Great.
From tomorrow, no, not today's.
18.
Next.
For item number 18 and 19, I'm paying for not today.
First order has disturbed everyone. Yes.
19.
18, please make your submission. Yes. State. 18 state. You're appearing.
18 Malad, it was fixed for charge, so we have to return the CD, 1 day accommodation.
Not today. Next. 19.
My lord, 19, I'm for 1 day accommodation. 19, my lord. Kindly.
I'll not allow any not today's from tomorrow.
My
Let me
lord.
be very clear.
My lord.
Not today. First day. Okay, fine. 20.
20, my lord, I'm appearing for the state.
Petitioner.
Petition was filed on 5th of December 2025, my lord.
Anyone for the petitioner? Let it be not today.
My lord.
Next. 21.
I'm paying for not this week.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 16th. 16th February. Next. You're appearing. 22.
Lordship, I'm for the petition. Lordship, the allegation is under
Give me a
section.
minute. Who's appearing for the state? 22 state. Anyone for the state in 22?
My 23.
The state doesn't choose to appear. Yes, please make your submission. No objection from the state. Yes.
Lordships, I think the CD rolled by another person's.
So that
Mr.
that
1 day
person should be there in court.
Lordships, just for a few minutes, I will check it as because I am holding 23. I'm getting ready 23. 22, I will check. And it pass over.
2 p.m.
They can now cut
Since she's ready, 2 p.m. 22, 2 p.m.
23.
Twenty-three.
I'm paying for 1 day accommodation.
Not today.
24.
But I am appealing for this case.
Passover not possible, madam. Please make your submission. Make your submission.
One day accommodation.
Not today. All the matters will get discussed.
25. 25.
I am appealing for this case.
Petitioner. What happened? Not today.
26.
26, my lord, I have misplaced the brief. Kindly make it not today.
In one day, you'll find your brief.
No, my lord. My lord, actually, my brief is lying on my chamber, so
Not
misplaced.
today.
27.
Not today.
28.
Not today.
29.
Now for the statement.
No one for the petitioner. Not today. Petitioner. Yes.
Lordship, the brief. My clerk has left the brief in court number 1. It is bringing it out. She has come.
Yes.
Lordship, apology, Lordship, for. As Lordship found out, this is a case of NDPS. The petitioner is in custody for 17 days. Now, Lordship, what has been recovered is, as per the seizure list, page 14, there is 27 kgs of ganja. Now, which is apparently a commercial quantity. Page 15, Lordship will find that the arrest memo is there, but the grounds of arrest has not been communicated in whatsoever manner. Page 15, Lordship. Charge sheet has been submitted, 11 witnesses showing, but my submission before your Lordship is that there is been serious non-compliance of section 42 of the NDPS Act. Another point is that the search and seizure, as because Lordship, I have the certified copies, 3 witnesses has been examined, which shows apparently the search was conducted prior to the arrival of the executive magistrate, which is totally illegal in the eye of law. Lordship, if for the first point, may I hand over the 3 witnesses, official witnesses examined? Given. Yes. Lordship, kindly sees the PW2 first. That is the constable of Mathamanga police station. Please kindly turns up the page and answer to question number 2 in cross-examination. May I read along, Lordship? I cannot say whether there was any CCTV camera in outside of the delivery courier office, but there was a CCTV camera inside the office. On seeing us, the rider fled away to unknown with his motorcycle. Now, the apprehended person was searched by SI Kapil Dev Roy, and a mobile phone was recovered during his personal search at 8 p.m. On opening of the sack at 8 p.m., this is relevant, Lordship. On opening of the sack at 8 p.m. by SI Kapil Dev Roy, Gaja was found. Thereafter, executive magistrate arrived at 11:30 p.m. Neither myself, SI Kapil Dev Roy, nor any other police personnel were searched before the search of the accused person. This is admitted by the police official who has deposed. Now, Lordship, kindly sees the PW1, that is the Kapil Dev Roy, in his examination in chief, in answering to question number 3, Lordship. Can you see? I then offered him for mutual search in presence of the gazetted officer and issue a notice to him, and he agreed to be searched in presence of executive magistrate. Thereafter, on 23:35 hours, DMDC, that is the executive magistrate, Lordship, came to the
You're
spot.
reading question 3. It is a fact in carbon copies.
Lordship, of course, PW1.
PW1 cross-examination.
No, examination
Chief.
chief. Now we have found from the deposition of PW2 that the bag sack was opened on 8:30. Executive magistrate arrived subsequently. But here, what this Kapil Dev Roy, who according to PW3, searched the person, Lordship. Can you see? I then offered him mutual search in presence of gazetted officer and issued a notice to him, and then he agreed to be searched in presence of executive magistrate. Thereafter, on 23:35 hours, that is the Sri Raja Gopal Mukherjee, that is the executive magistrate, came to the spot, who asked the detained person about the incident. When the detained person confessed the incident objected to, I then served notice under 100 CRPC. So this person says that the search was conducted in presence of executive magistrate, but his police personnel, member of the raiding team, being the PW2, says that the PW1, Kapil Dev Roy, already has done the search and seizure prior to arrival of the executive magistrate. Not only that, Lordship, but prior to search, the police persons were not even searched.
There are controversies, I mean discrepancies.
Discrepancies.
The other, PW1 says that there was a mutual search.
Mutual search. But PW2, being a police personnel, says that already the search was conducted by the PW1 prior to arrival of the.
One is also a police person.
Yes, Lordship, he is the complainant. He is the complainant. Now he has been contradicted. And Lordship kindly says that 42, that is apparently, Lordship, from page 10 is the written complaint. Lordship will find that admittedly, if Lordship sees the answer to cross-examination of PW1 answer, may I read, Lordship? I cannot recollect in which section the search and seizure was done by me, or that I cannot recollect about the compliance of necessary section. There was a specific information about the motorcycle. I reduced the information in writing. I sent the writing information to my superior officer, who is a gazetted officer, who gave any written authorization to me, but I did not find today in court. The said written authorization was not seized by the IO from me. The written source information is not shown to me today, or that the same was not seized by the IO from me. I did not intimate my superior in writing about the search and seizure.
There are discrepancies.
So he did not intimate his superior about the seizure in writing, which is non-compliance section 42(2). And Lordship knows better than me that in such a case, Lordship has Lordship, I hand over an order on the self-same issue. In another case, my lord has dealt the issue. Correct. No. Lordship, this is a division bench order of our High Court. Oh.
From where was the seizure made?
Lordship, seizure. This is the most peculiar thing, Lordship. And it sees the seizure list, which is page 14, Lordship. In front of page 14, place of seizure, in front of delivery courier office, situated in ward number 10, PS Mathamanga district, Kuch Bihar.
So how is 42 attracted? How is 42 attracted?
Lordship, there was a private bike. The rider fled away. It is the case of the
the
prosecutor.
seizure from the bike? No.
Lordship, it is not mentioned. From the written complaint, Lordship will find that the person who was riding the bike and this person was in a bike. But seeing the police party, it is allegedly stated that the rider with the motorcycle fled away, leaving this person. First paragraph, Lordship. Page 11, third paragraph.
The seizure is not from the bike.
Lordship, kindly see at about 25 hours, page 11, Lordship, complaint. At the top, Lordship, third paragraph. What is, Lordship? At about 20:05 hours, we noticed that a motorcycle without number plate approaching towards us. We tried to intercept the said motorcycle, but they tried to flee away. Somehow we managed to apprehend the pillion rider along with the above noted contraband articles. So they apprehended the pillion rider who was in the motorcycle. It is allegedly the case of the prosecution that the rider fled away.
But what is the place of seizure?
In front of a courier office, the delivery courier office.
Yes, they had already sent it to the courier office, so it's not from the bike.
They have sent it, Lordship?
To the courier office.
Lordship, as per the case of the prosecution, they noticed that two persons are coming with a bike in front of a courier office. When they apprehended, the rider fled away with the bike, leaving the pillion rider along with the articles. Third paragraph says.
And he was carrying it to the courier office.
By the bike.
Let me hear the statement.
Lordships.
Yes.
First of all, I would submit before your Lordships the one examination chiefs and the cross examination one discrepancy is not a entire case.
Did
is
you
thrown out.
videograph? Did you videograph the entire seizure?
Yes, Lordships, according to prosecution's case. And Lordships, until the others raised evidence is still pending, your Lordships. At this juncture, and so far the case is concerned, it's a commercial quantity, 37 bar, your Lordships. I'm very, my colleague trying to cloud, but there is no cloud, your Lordships. From the PW1, it is clear. And the so far one cross-examination, one discrimination, they have found out it may be.
Does the
After-
seizure list bear the signature of the executive magistrate?
Yes, Lordship, there is a seizure list itself clear.
Which page?
Actually, I have obtained.
Lordship,
Have you annexed the seizure list?
Lordship, page 14. Now,
Where is the executive magistrate's signature in the seizure list? To show that it was done in his presence.
Lordship, here I have obtained the certified copy of the
Seizure list.
yes, CD, Lordships. And
Yes, seizure list is page 14 of the application.
same seal list perhaps.
Lordship, I direct the I have
They are
original.
two independent. They are two independent witnesses.
Yes, yes, Lordships.
Where is the compliance? Has to be done before the executive magistrate, and where is the videograph?
Lordship, then I will.
The charge sheet does not contain any device of videography.
Contentions, but by contentions, everything is. Lordship, let
Should be part of the CD. Please show me.
Yes, but they have sent me the certified copy, original CD sent by the trial court, as because sometimes the matter is pending here and the trial court is hampered.
But this is the entire CD, sir. Maybe
Yes,
the
Lordship,
certified copy, but
I
it's the
will call
entire CD.
entire CD. Original CD is very much required, Lordship, as because they have raised some.
What difference will it make with your original CD?
So some portion is not visible. Lordship, can you see the seizure list?
Page 14 of the
Page 14 of
application
my
is
document.
absolutely legible. And these discrepancies cannot be removed, these contradictions. They are already on record. I do not find the executive magistrate being present at the time of seizure. That's mandatory.
I just confirm by.
How else will you confirm, sir?
Sometimes some discrepancy is lost.
Seizure list is on record. Let him face trial. Let him face trial. Learned counsel for the petitioner submits that the petitioner is in custody for more than 300 days. Stop trial has commenced. There are several contradictions / discrepancies in the version of the witnesses examined so far. The seizure was done before arrival of the executive magistrate. Was there a videograph of the?
No, Lordship.
And
The charge sheet does not contain any
the
device.
seizure was not videographed in accordance with law. Learned counsel alleges violation of section 42 of the NDPS Act. Paragraph. Learned counsel for the state opposes the prayer. Paragraph, I have considered the material on record. It prima facie appears from the evidence led by the de facto complainant as well as Selim is a seizure witness.
Lordship, 7 PW2 and PW3, 3 witnesses have been examined. These are all police witnesses.
It appears from the evidence of witnesses, including the de facto complainant,
More than 300 days.
that the witnesses have made contradictory statements. The presence of the executive magistrate at the time of the seizure and videograph of the said seizure are not found in the evidence led by witnesses. The case diary does not reflect compliance of section 42 of the NDPS Act. In view of the above, this court is inclined to hold that the petitioner has been able to rebut the statutory restrictions under section 37 of the NDPS Act and is entitled to bail. Paragraph, accordingly, brief of bail is allowed. The petitioner, namely, such and such, be released on bail on furnishing bond of rupees 20,000 with 2 sureties of like amount each, one of whom should be local, to the satisfaction of
Lordship, NDPS court,
additional session judge.
Kuch Bihar, first court Kuch Bihar.
The learned
Additional session judge, first court, NDPS Kuch Bihar.
additional sessions judge,
First court, NDPS Kuch Bihar.
first court within bracket NDPS,
This is the designated court.
Kuch Bihar, subject to condition that which jurisdiction is
Mathapanga
this?
police station, Lordship.
He shall remain within Mathapanga.
Mathapanga. Lordship, the court is in Kuch Bihar. The cases of Mathapanga. Because Mathapanga does not have any NDPS, not leave the jurisdiction of Kuch Bihar district, Lordship.
Let him remain within Kuch Bihar,
Kuch Bihar.
within the trial courts.
Grateful,
My
Lordship.
strong objection can be noted as because the matter is.
I have recorded.
Recorded.
I have recorded that.
Strong objection
I have
because
recorded that.
Only they have completed 2 and 3.
I have recorded that. Yes. He shall remain within the jurisdiction of the learned trial court.
Lordship.
And he's a resident of
Is a resident of Lordship.
Dangapara, so he can remain in his own house. That's
Lordship,
within the trial court's
Kuchbihar,
jurisdiction.
district
right?
Kuchbihar.
Yeah. And shall appear before the learned trial court on every date of hearing. Stop, he shall not intimidate witnesses or tamper with evidence in any manner whatsoever. Paragraph, in the event the petitioner fails to adhere to any of the conditions stated above, comma, the trial court shall be at liberty to cancel his bill in accordance with law without further reference to this court. CRM disposed of. As I said,
Deeply obliged.
case divided. Next.
Thirty-one, 30.
Lordship, I am for the petition.
30.
30.
Yes.
Lordship, my bail prayer was earlier rejected. Can you see page 9? Can you see page 9? It was rejected on 1st May 2025 and subsequently on 7th July 2025 by your Lordship. Page 11.
Any change of circumstance?
Yes, Lordship. Yes, Lordship. I'm coming to that. He's in custody for 601 days as on today. Now, Lordship, this is the last order of the court which I have obtained from
So one of the accused is still absconding.
Still absconding. Now, Lordship, on this point, Lordship, I would like to refer Lordship, I have to refer one order of our High Court, Lordship. This was passed on 18/11/25. In CRM NDPS 1430 of 2025. What you kindly see is here the same condition was that charge sheet has been submitted till date, charge not framed. Another accused person has been absconding. So, considering all those facts, Honorable Justice has allowed the prayer of the bail.
Section 37 has not been considered.
Lordship, that long-standing delay.
You're in custody for how long?
Lordship, 600 on one day.
600?
On one day. Charge not framed. Now, Lordship,
So you're only on delay, right?
I'm only on
Article
day.
21.
Lordship,
Yes.
I may place another judgment of Honorable Apex Court on the similar point, which was passed on 27/10/2025, Lordship.
Kapil Walha.
No. Kapil Walha, no. Shubhashil. Lordship, kindly, this is page second paragraph. Considering the facts and the circumstances of the case and period of incarceration undergone by the petitioner, that is since 3rd January 2025. Order was passed on 27/10/2025. So only 10 months delay was there. Honorable Apex Court granted bail. Lordship, another judgment I would like to refer of Apex Court only.
Article 21.
Lordship,
You're on Article 21, right?
Article 21. Lordship, 1/5/2025, this was passed. And here also, Lordship will find that more than 1 year.
Let me hear the state. Because you're only on delay.
Only 1 year, because the PO has been transferred. And on this ground, Lordship, one indulgence, Lordship, PO has been transferred, delay. Honorable Apex Court, Lordship, kindly sees the second
But now
paragraph.
the PO has joined, right?
No, Lordship.
The other order?
This order.
Oh, he's in charge.
Lordship, kindly sees the second paragraph of the order I have given just of 12th December 2025 order.
You've referred to this judgment, this
No,
order.
Lordship, Rafiqul Mandul. No.
Alamgir and another.
No, Rafiqul Mandul I am giving now.
You've given Alamgir again.
Rafiqul Mandul. So just now I have given Rafiqul Mandul. Lordship, I am giving another. Sorry, Lordship.
You've given us
Extremely
another
sorry.
copy of Alamgir.
Extremely sorry, Lordship. It's my mistake. Lordship, can you see the second paragraph? Learned advocate for the state opposes the prayer for bail and submits that the delay in the trial is because the accused person and there being no presiding officer in the court. And the contraband was seized 9,000 bottles. But bail was allowed.
Let me hear the statement.
I'm on this point only.
Lordship, actually, my learned friend's entire argument is based on the delayed trial. Actually, the the last order which my learned friend placed before your Lordship, here it has been written, Judge Special Court NDPS. Here the contention of PO is vacant. The contention of PO is vacant has not been corroborated because it
Please
has
see
been
the
written
signature in charge.
Judge Special Court NDPS, Lordship.
IC in bracket.
Oh, in IC.
And last line is PO strong.
Lordship, there is a no straight jacket formula regarding the to ascertain the delay. It's a case of NDPS where there is a bar. It's no doubt it's a draconian law where there is a bar of
More
section
than
30.
600 days.
More than 600 days. But Lordship, in Kapil Vadha, the Honorable Apex Court has clearly observed that the heinousness of the offence, its impact on the gravity of the society, and also the nature of the offence. The nature of the offence has to be taken into consideration even while taking into the consideration of delay. Lordship, two times his bail applications was turned down. At first on merits. And Lordship, charge sheet has already been submitted, and one accused who is absconding. They are the part of the same racket. So now they are trying to yield the opportunity. Now that they are trying to yield the opportunity, one is
What steps
absconding.
have you taken for arrest
Yes,
of this?
Lordship,
accused?
warrant of arrest has been issued. Warrant of
That's
arrest.
all.
Warrant of arrest has been issued.
Lordship, charge sheet was sub-
Lordship, let me take one instruction whether the WPA has been issued or
No,
not.
Let him face trial.
Lordship, charge sheets are submitted 11/12/2024.
I have
Lordship,
pronounced my order.
Lordship.
My strong objection may kindly be noted.
Absolutely, very strong objection, I record. The
May I
petitioner
apologize?
is in custody for more than 600 days and seeks bail primarily on the ground of prolonged incarceration. Paragraph, learned counsel for the state raises strong objection. Paragraph 2. Paragraph. It appears that the petitioner is in custody for more than 600 days. One of the co-accused is still, though charge sheet has been submitted, comma, one of the co-accused is still absconding. The trial court is also lying vacant. There is remote possibility of trial being concluded in near future. Paragraph, learned counsel for the petitioner has referred to several orders passed by the Honorable Supreme Court granting bail to the accused solely on the ground of delay in trial. Paragraph. It is a fact that almost 14,000 pieces of PYN SPAS SPAS PYN NY PYN SPAS SPAS capsules were recovered from the possession of the petitioner. Stop. Without going into the merits of the case, comma, this court is inclined to release the petitioner on bail solely on the touchstone of Article 21 of the Constitution of India. Paragraph, accordingly, prayer for bail is allowed. The petitioner will be released on bail on furnishing bond of rupees 20,000 with 2 sureties of like amount each, comma, one of whom should be local, comma, to the satisfaction of
Lordship, NDPS Court, Alipurduar.
One in Laj's
the learned.
He should not leave the jurisdiction of Alipurduar district.
Absolutely, absolutely. Any other condition you want, I'll impose.
No.
Within the trial court, right?
Yes.
Lordship.
Bail is ultimately.
The learned additional district and sessions judge, within bracket NDPS, right?
NDPS,
Comma, Alipurduar, subject to condition that he shall remain within the jurisdiction of the learned trial court. Is he remaining in within
No,
the-
Lordship, he is a resident of Kalchini police station.
So that's beyond.
Which is within
Within the
the
trial
Within
court
Alipurduar district.
within the
Jurisdiction,
jurisdiction.
right.
Alipurduar.
And shall appear before the learned trial court on every date of hearing. He shall not tamper with evidence or intimidate witnesses in any manner whatsoever. Paragraph, in the event the petitioner fails to adhere to any of the conditions stated above, comma, the learned trial court shall be at liberty to cancel his will in accordance with law without further reference to this court.
Deeply obliged, Lordship.
CRM
Deeply
is
obliged.
posted, or is it better? Next.
31,
Lordship, I am praying for 1 day.
Not today.
Not today.
32,
Case for Lordship.
32, 33, and 34, my lord. Bring for not today.
Not today. Please be ready tomorrow, sir. I will not grant an adjournment tomorrow. Next.
35,
Yes.
I am on behalf of the petitioner.
I'm on behalf of the state.
My lord, the present petitioner is in custody for 1 year, 7 months, my lord. And the one of the accused person is still absconding, my lord. And in, my lord, in the case of
2nd of June 2020.
Kapil Wadhwa, my lord,
You are on Article 21.
Article 21, I have 3 points to be made, my lord. This is the judgment, my lord. Kapil Wadhwa's judgment, my lord. Para 19, my lord. It clearly says, the court noted that even under special penal statutes prescribing a higher threshold for
Yes,
grant
sir,
of-
that's settled.
My lord, my lord,
That's
my lord,
settled.
my lord. That is one point, my lord. My second point is, the ground of arrest was not communicated to the accused person, my lord. If your lordship sees the memo of arrest, my lord, page 14, my lord. The petitioner has signed in Bengali and no ground of arrest.
Charge is over.
Not-
Charge
not
is not
yet,
framed,
not
my
yet,
lord.
not yet, my
One of the accused persons still absconding.
Please
One
come to page 10 of the earlier order.
page
You
10.
are granted liberty to approach the court after the stage of consideration of charge was over. So that stage has not reached as yet.
My lord, one of the accused person is still absconding, my lord. That is a problem, my lord.
Please see page 10, coordinate bench's order.
My lord, that I understand, my lord. But the thing is that
So
one
there
of
is no change in
my
circumstance.
lord, the one thing is to be done is, my lord, until unless that person is arrested, my lord, the charge cannot be framed and he's still absconding, my lord. That is the problem, and he's in custody for 1 year, 7 months, my lord. And most importantly, 52A has not been complied in this case, my lord. The sample was sent on 5/6, whereas the certificate of inventory was done on 11/6. My lord, if your lordship kindly sees the CD, my lord, because I have not been provided with the documents, but the lower court counsel have informed me about the same, my lord. And in support of that contention, my lord, I rely on a Supreme Court judgment, my lord. Suryapalli Srinivas.
There was a direction for splitting up trial. Has that been done?
No, it's
Not
been
yet,
done, my lord.
But next date is fixed on, my lord, 26th of March 2026 for appearance year and of WA. WA.
There is a specific direction for exhausting all process, splitting up trial. Where is all that?
My lord.
Not complied with.
Nothing, my lord. My lord, in the said judgment, my lord, in para number 15, my lord, the Honorable Supreme Court had stated, my lord, that when we have also found from the materials on record that there has been clear non-compliance with the provision contained in section 52A of the NDPS Act, either possibly due to the lack of experience of the investigating officer or his lack of knowledge of the relevant provision of the NDPS Act. There were lapses which were duly noted by the session judge. Thus, we are unable to hold that there was primary and reliable evidence before the trial court in respect of the offence committed, my lord, and based on which he was acquitted, my lord. And this judgment also refers to the Kasif judgment, my lord, in para 8,
This is not at the bail stage.
my lord. But my
This
lord,
is after trial.
but my lord, subsequently, if 52A is not complied, my lord, it will lead to the acquittal of the accused person, my lord. And he's already in custody for 1 year, 7 months, my lord. He just happens to be the driver of the vehicle, my
I'll
lord.
request the state to show me compliance of 52A
My lord.
from the CV. Please show me.
My lord, but the case was initiated on 2nd of June 2024, and the seizure was also made on the same day. But 36.129 kg of ganja. Commercial quantity was recovered from the petitioner, my lord. My lord, the inventory was done on 3rd of June 2024. Inventory was done, and the certificate of correctness was issued on 11th of June 2024. That is, my lord, after
The sample,
7 days, 8 days.
a sample was in
But sample was sent on, my lord, 5th of June.
3rd, 5th and 11th.
yes.
My lord.
The sample was
certificate,
already sent, and thereafter the certificate was done.
that's true, my lord. The
The
sample,
language is as soon as may be.
my lord.
But
But it has to
that
the sam-
varies from case to case,
my lord,
right?
my lord. But the sample has to be taken in front of the magistrate, my lord. That was not done, my lord.
my lord,
Please show me.
kindly see the page 32, the inventory.
The sample was not taken in front of the magistrate, my lord. Neither on the spot, my lord. Which
Page
sample
32
was
is the
sent, my lord?
inventory, my lord.
Fifty-two doesn't say it has to be taken in front of the magistrate. It has to be sent to the magistrate.
My lord, but the
For-
sample, if the sample was taken
For
on
the
the spot,
purpose of certifying the genuineness, etc.
absolutely, my lord. But the thing is that then the sample has to be taken in front of someone, my lord, either in front of the accused or the magistrate. Over here, my lord, in front of whom the sample was taken, because on the spot the sample was not taken as per the FIR, my lord. In front of whom the sample was taken and sent to the CFSL, my lord.
My lord, kindly see page 67, the certificate of correctness issued by the magistrate, my lord.
When was it issued? When was this issued?
My lord, date
11th.
11th of June 2020.
Whereas the sample was sent on 5th.
Third, it was seized. Fourth, itself, it was fixed for certification
Yes.
the next day. So at this stage, I really do not find a non-compliance of 52A.
My lord, if it is done, the certificate of inventory is done. on
More
11th.
so, there was
If
a
the
direction
sample is
on
sent-
you to approach this court after the stage of consideration of charge.
My
I'll
lord,
again direct the trial court to exhaust the process and take
my lord, she's already in
split up
custody
trial.
for 1 year, 7 months, my lord. The direction was of court was never complied with.
I
my
would
lord.
have considered it otherwise if this order was not staring at my face. I have an earlier order of this court,
My lord.
which says that you can approach only after the stage of consideration of charge is over.
But
That
the-
is when trial is going
But
on.
if the person who is the co-accused is never arrested, my lord, how many years will he stay in custody, my lord? I have come after a long delay, my lord. It's not so immediately after rejection I have come, my lord.
It was rejected in June. You've come up after 8 months.
Yes, my lord. After 8 months, and no splitting of trial was done.
Has
Charges
there been
was
any
not
splitting
framed.
of trial or
No,
anything?
no,
Nothing
no,
was done, my
my
lord.
lord. Next date is fixed on my lord, 26th of March.
For
2000
production.
for my lord, appearance and ER of WA of the
Let him remain within
absconding.
jurisdiction. 1 year, 7 months, and the trial
grateful,
court does
my lord.
nothing.
Grateful, my lord. Grateful.
Well, kindly note my objection, my lord.
Learned
Because of the
counsel
commercial
for
quantities recovered.
these orders should be communicated to the trial court
My
and
lord,
complied with in its strict sense.
My lord.
A person remaining in custody for 1 year and 7
Well,
months and the
I can-
trial
I
court
can
sits
understand.
tight over it
Yes, my lord.
can't be helped.
That's true, my lord.
Uh, The petitioner is in custody for 1 year and 7 months and prays for bail. Learned counsel for the petitioner submits that despite an order passed by this court, the co-accused has neither been arrested, nor any steps taken by the learned trial court for splitting up of trial. The petitioner seeks bail primarily on the ground of prolonged incarceration. Paragraph. Learned counsel for the state vehemently opposes the prayer. Paragraph, I have considered the material on record. Paragraph, by an order passed on by an order turning down the bail prayer of the petitioner on 9th June 2025, comma, a coordinate bench of this court directed the learned trial court to take steps for exhausting all the process of law, comma, split up the trial and take further steps so that within 60 days from the next date so fixed, steps be taken for overcoming the stage of consideration of charge. Despite such order, comma, the co-accused is yet to be apprehended. Stop trial has not been split. Paragraph. Though contraband article of commercial quantity has been recovered from the petitioner, comma, this court is inclined to release the petitioner on bail solely on the touchstone of Article 21 of the Constitution of India, comma, without going into the merits of the case. Paragraph, accordingly, preferable is allowed. Paragraph, the petitioner, namely such and namely such and such, be released on bail on furnishing bond of rupees 10 with 20,000 with 2 sureties of like amount each, comma, one of whom should be local, comma, to the satisfaction of
Additional session.
the learned additional district and sessions judge, comma,
Siliguri.
second court within bracket NDPS Act, comma, Siliguri, subject to condition that he shall remain within the jurisdiction of the learned trial court. Is he already remaining within the trial court's jurisdiction, or is beyond that?
Resident of Malad,
Dinajpur.
He's a resident of Balurghat, right? And
Actually,
shall
Dinaj-
furnish the
Look,
address
that's
where
in
he shall
Dinajpur.
presently reside before the learned trial court, comma, the investigating officer and the officer in charge of the police station under whose jurisdiction he shall presently reside. Stop, he shall appear before the learned trial court on every date of hearing and shall not tamper with evidence or intimidate witnesses in any manner whatsoever. Paragraph, in the event the petitioner fails to adhere to any of the conditions stated above, comma, the learned trial court shall be at liberty to cancel his will in accordance with law without further reference to this court.
grateful.
Great.
Disposed of, urgent certified website copy, case diary will return.
36 টা দে।
CDV returned to Kolkata. Next.
Lordship,
36.
praying for 1 day accommodation. Your Lordship.
Not today. Please be ready tomorrow, sir. I'll not grant such accommodation from tomorrow. Next.
37.
37
Yes,
Monday.
Monday. State, 37? No one, 37. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 16th February. Next.
38.
I'm for the state binder.
Yes.
My lord, this is NDPS, my lord. In NDPS, cases search and seizure and the examination of sample are the both prime factors. Now, in this case, both these factors are shrouded with mystery, my lord. If my lord kindly.
Charge sheet submitted or
Charge sheet
investigation is
submitted,
going
my
on?
lord. Charge sheet submitted. If my lord kindly comes to the page number 21, that is FIR. Yes, my lord, page number 22 at second page of FIR.
There are several earlier rejections, right?
Yes, yes, my lord, but the thing is that he is behind the bar for more than 865 days. Till date, and the circumstances are there are a lot of discrepancies, my lord. If my lord kindly comes to page number 22, the last paragraph. In the fourth line of the last paragraph,
Page?
page number 22, my lord. Second page of the FIR.
Yes.
Last paragraph, my lord. It was stated that the secret source in that on 29/9/2023 at 14:40 hours, I received a reliable specific input from two persons stored huge quantity of illegal calf in their rented house. And after on 29th, but it was diarized on 30th, my lord, not immediately. Number one. Number two, my lord.
On merits, it was turned down on several occasions. What is
Still,
the
my-
stage of trial?
Still, 4 witnesses have been examined, my lord.
Out of?
Out of 15 witnesses. And that witnesses are also in my favor. I will show that, my lord. So, my lord, on 29th, source information was received, but not immediately it was diarized. It was diarized after 1 day, on 30th. Number one, my lord. Number two, my lord, it is now mandatory that videography has to be done, my lord. Now, videography of the search and seizure has to be mandatorily done, my lord. Now, 23, page number 23, FIR, my lord. In the second paragraph, it has been stated, my lord, at about 15:20, I, along with the movement of the
All
officers.
these submissions have been taken into consideration by the earlier benches, I find.
No, my
There
lord.
are observations.
My lord, still, now the now the what the exam.
So this court will not take a different view. What is your change in circumstance?
My lord, the deposition is totally in my favor.
Please show me the
pit-
depositions.
My lord, my page number 20.
The last rejection was in June, right?
Yes, ma'am.
Page number 20.
20, my lord. Cross examination. That is the only witness, independent witness that has been examined.
He has been declared hostile. Where are the other witnesses?
This is the only independent witness. Other was the police witnesses. There were another witnesses. He did not come. This is the one witness. He clearly stated that my signature was taken at the police station, and all the circumstances are showing that it has not happened and that way. Videography was not done, my lord. Videography has not been done. So this videography, it was stated that search and seizure started at 15:30, that is 3:30 p.m. Whereas the videographer himself stated that I come to the PO at 6. He was called at 6. It is in the. It must be in the CD. I have not annexed it. I have got a copy.
Has the videographer been examined?
No,
So please wait for the examinations.
my lord.
How many more witnesses are left? Yes, let me hear the state. 4 witnesses are examined.
4 examiners. There are
How many
15
are left?
witnesses. They are behind the bar for 865 days, my lord. And medical condition, my lord. I have they, for about 17 times he have been sent to the medical college. It's very much ill, my lord.
Where are those documents?
I have annexed it, my lord.
These are all of 2024. The
No,
medical documents.
no.
Please show me a recent document.
Recent, my lord.
At page?
My page number 34, my lord. Page number 32. Page number, if my lord takes it from 32, that is the from RTI. There are dates on 2/11/2023, 4/11/2023, 8/11/2000. There are 17 dates on which he has been sent to the medical college, my lord. Then page number 34, my lord.
For outdoor treatment.
For treatment, he was there is stone and kidney has been damaged. An operation is needed. Page number 34, my lord. It has been stated that to attend NBMC surgery OPD after discharge. So, my lord, on any condition.
What is the ailment?
Ailment is there is in kidney there is.
Where is that stated?
All the documents I have stated. This is medical.
That
my
there is
lord.
a kidney stone. Please show me.
My lord, page number 35, liver, all these things has
Kidney
been
is not
stated. This is
liver,
medical
sir.
terms now. It's hard for me, but it is there, my lord. And that's why normally a person from jail to go to the medical college is very hard, my lord. But there is jail authorities themselves send them to the medical college for 17 times. Continuously, my lord.
Let me hear the state.
Lordships.
What is the stage of trial? On merits, it has been turned down several times.
Your Lordships, my one attention before your Lordships. Can we see the last order? They have pages 16, Lordships.
Yes, I've seen
And
that.
they have given by your coordinate bench that the one direction given that the trial may be disposed of within a year. Lordships, so far that order also appeal is pending, and so far they have alleging that there is no videography has been done. But so far my CD is concerned, there is a
No,
reflections-
no, my lord.
reflections of the videography and others.
The special
my
judge
lord,
was, just a minute, on merits, I will not consider for
My
this,
lord.
sir, there are several
My lord,
considerations.
my lord.
The special judge was directed to conclude the trial preferably within 1 year from date.
My lord.
The date was 30th June 25. We have not reached the date as yet.
But till
is a
date,
premature stage.
only 4 witnesses. After that order, only 2
You
witnesses.
can come back after this.
My lord, on medical ground, but at least for that person. This is for the one person, my lord.
No,
Two
no, he is
petitioners.
visiting the outdoor. He is being treated at the hospital.
My
at
lord,
the-
surgery is needed. It will be
The,
difficult
the
to
office,
operate
the,
the. At least for the
correctional-
petition. At
the
least for the.
superintendent of the correctional home will take charge of that.
My lord, at least for the petition number 2, my lord. For long he has been there, and there is
Your
actually.
application will be rejected as premature. There's a direction to come back after a year, not now.
But my lord, there is no substantial progress. 50 out of 50 after that order.
Please come back after, if this order is not compliant. Bail prayer of the petitioners was turned down by this court on several occasions, considering the merits of the case. The petitioner seeks bail primarily on medical grounds. Learned counsel for the state opposes the prayer. Paragraph, it appears that though the petitioner appears to be medically unstable, his treatment is being arranged by the correctional home regularly. Stop. In the event the petitioner requires any surgery as submitted by learned counsel for the petitioner, the superintendent of the concerned correctional home shall take necessary steps in this regard. Paragraph. By an order passed on 30th June 2025, rejecting the bail prayer of the petitioners, a coordinate bench of this court directed the learned special judge to conclude the trial as early as possible, preferably within 1 year from date. Stop. The present application appears to be premature. Paragraph, considering the material on record, prayer for bail is rejected at this stage. Please wait for some time.
Premature stage, Your Lordship, at this.
Next.
39.
39, I'm.
Lordship, 39 paying for 1 day, Lordship, because CD is not available. Earlier, CD would be
Not
after
today.
return. Tomorrow.
Next. 40.
40, my lord, also case diary is not available. My lord, kindly make it day after tomorrow, my lord. As because my lord, the case is of my lord, Coach Bihar Kotwali police station.
Learned counsel for the petitioner seeks accommodation. Let the matter
But
appear
state.
under the same heading. Learned counsel for the state seeks accommodation. Let the matter appear under the same heading on 13th
My lord,
13th February.
my lord.
Next.
41. 41.
Now for the state.
Not today.
42.
To pay for already not.
Not today. Please be ready tomorrow.
43.
Lordship, I'm paying for next week.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 16th February. Next.
44.
Lordship, I'm praying for not today. Not today.
45.
My lord, kindly fix the matter on Tuesday. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 17th. 17th February. Next.
46.
Paying for short possible, conducting it with court number 6. Short possible.
Come back at 2 p.m. in that case.
Grateful man.
47.
This one, my lord, I am for the petitioner.
State.
My lord, this is my renewal of bail application. On 18th June 2025, my lord, page number 9, my bail application was turned down by the Honorable Court with a liberty to file bail application after completion of the 3 witnesses, that is, my lord, CSW 17, 18, and 19. And these 3 witnesses have been done, my lord. These are the copies of the deposition. Now, my lord, the case is that deposition. My lord, the case is that on 29th December 2024, the complainant held a raid at the house of one MD Rohim, and from there some narcotics substance and some contraband articles were recovered. And after arresting that MD Rohim, from the statement of that MD Rohim, my name appeared, my lord. And thereafter, police conducted search in my medical shop. My lord, I am a medical shop owner having proper drug license. At page number, my lord, 12, my drug license, current drug license, which is valid up to 23rd March 2026, is lying, my lord. And these are my previous drug licenses. And my lord, from my medical shop, some drugs have been recovered, lying at page number 17. That is the seizure list. RC cough syrup containing codeine, tramadol hydrochloride containing tramadol, and nitrazepam tablets. My lord, if takes up the drugs and cosmetics rules under Schedule H1, my lord, all are covered. And I was holding such drugs with proper drug license, my lord. All these things are covered under Schedule H1 drug, my lord. And my lord, from the deposition itself clear that the place of occurrence is the medical shop. If my lord takes up the deposition of the witnesses, independent witnesses, that is Nathu Rai. First, there is CSW 17, my lord.
Have you annexed the depositions?
My lord, I have filed the certified copy. Certified copy. These are the drug license certificate. In the chief, my lord, on 6 January 2025 at 11 AM, I found gathering of police in a medical shop, which is close to my shop. My shop is situated at Odlabadi Bazar. It is a Xerox shop, but that is the shop of the witness. Police called me. I was informed that the medical shop would be searched. I was requested to remain present at searches. Thereafter, notice was issued to me. This is the carbon copy, and the search was conducted. The medical shop was searched. And that is the second witness, my lord. That is another Caesar witness, Shailesh Singh. He also deposed, my lord, that on 6 January 2025 at about 12 to 12:30 PM, I met police at the local market. A notice was served upon me by the police. I accepted the notice, putting signature. This is my signature. Police took me to the house of Babuda. Babuda is present in court. Witness is identifying me. That is Sanjeev Sarkar, petitioner, as Babuda. I entered in the house of Babuda with police. There is a medicine shop in that house. And that medicine shop was searched and these things was recovered. And the executive magistrate, my lord, that is Arun Patro, in his chief, because he is the executive magistrate, my lord, kindly consider one thing. He was supposed to support the version of the prosecution. In the chief, he never whispered about the medical shop. But in the cross-examination, it is duly appeared that there was a medical shop. In the cross-examination, my lord, there are several shops in the Odlabadi Bazar. It is commercial place, so far I can remember. There was a shoe selling shop near the PO house. I cannot remember. I found no drug controller, drug inspector at the PO. The medicine shop is lying on the front portion of the PO house. That is my house. That is my medical shop. My house was containing the medical shops adjacent. So the medical shop, my house was searched. I was holding the articles with proper drug license. But I have been implicated. My lord, I am in custody for 401 days. And there are total, my lord, 25 witnesses. And last witnesses as per deposition of executive magistrate, that is witness number 12 has been examined.
Let me hear the state.
My lord, the drug license was never produced before the investigation agency so that we can verify the same. till date, my lord. So my lord, 399 bottles of cough syrup and my lord, several types of total 15,000 tablets. Total 35,160
The Caesar
capsules.
is covered by H1 schedule.
My lord, they did not produce any they could not produce any document of the contraband before the investigation agency.
Purchase of contraband.
Yes, my lord. They never produced the documents.
Yes, what document?
Mere holding a drug license, no one can store such type of things.
Milord, as per my instructions, all these documents were shown at the time of incident, but they were not taken by the IO. That is my instruction.
Have you annexed the copies?
No, Milord, the originals have been taken away. Only I have the drug license, I have annexed it, Milord. And this is a medical shop, Milord. And on a same case, Milord, coordinate bench considered this thing, Milord.
He is holding the drug license.
Prima facie, it appears that
My
it's
lord,
under H1.
Maybe, my lord, they did not produce any document, purchase document of the contrabands to the investigation agency till date, my lord. Kindly consider this. He is holding the drug license, and behind that, my lord, he is selling the contrabands unlawfully.
If he has a drug license, the sale cannot be unlawful.
My lord, storage of the
Storage and sale both cannot be unlawful. Any document to show your valid purchase?
Milord, as per my instruction, these documents were taken at the time of incident, Milord.
Copies?
Nothing is with me, Milord. Only the drug license are there, and from the deposition is clear, but the things were in the
How is
in
it
my
possible,
medical
my
shop,
lord? The purchase maybe.
Yes, they were in your medical shop, and it also refers to an underground storage.
My lord.
Milord, the underground storage has only referred by the executive magistrate. The independent witnesses have never whispered about any underground storage, Milord.
For how many days are you in custody?
401 days, Milord.
How many witnesses left?
My lord. Total witnesses, my lord. Number of
25 total witnesses.
25.
How many are examined?
That is, I have to check, my lord.
Milord, as per the last witness, that is, as per instruction, Milord, that is executive magistrate, that has been taken as deposition of witness number 12. That means probably 13 witnesses are remaining.
Total 25.
Out of 25.
Out of 25.
Out of 25, 12 are examined.
12 were examined as
So
per
11, 13 more.
My lord, we need only 6 months to conclude the trial.
You need only 6 months?
Milord, it will.
I'll record 6 months, come back after 6
Malad.
months. Let me see. Because I am not able to see the documents.
My lord.
How you procured.
Milord, they kindly allow me chance, Milord, if I can keep it day after tomorrow, Milord, if I take instructions, if such documents can be produced, Milord. If any.
But after.
Let him come back to
Malad.
show whether
Malad.
he has documents.
But then, my lord, we have to verify these same through my investigation agency.
Milord,
whether the documents were forged or not. I have to verify this.
I'll keep it next week.
Milord.
Please give the documents to the IO in the meantime. Let him verify.
My lord.
Learned counsel for the petitioner submits that he holds a valid drug license under the Drugs and Cosmetics Act 1940 and was entitled to possess and sell the drugs under Schedule H1, H-1, capital H-1 of the Act from his shop. Learned counsel for the petitioner seeks to produce documents to substantiate his procurement of the said drugs. Paragraph, let the matter appear under the same heading. on 18th, 18th February 2026. Next.
18th. 18th. Grateful.
48,
Lordship paying for not today.
Not today.
49,
Not today.
No CBT.
50,
15 minutes I pray for a day's accommodation.
Not today.
51,
My Lord, I've just received the brief. My Lord, 1 day's accommodation.
Not today.
Just a day's accommodation. My Lord, one more thing, my Lord. My Lord, co-accused, my Lord, he is also preferred an application, my Lord. My Lord, same case diary, my Lord, that matter is not appearing in the list, my Lord. My Lord, shall I
It's
hand
not
it?
appearing in the
No,
list.
madam.
Give the number.
My Lord, I'll
Change
hand
it
over
to
the
corporate admin.
Great. Number 2. Great.
Next.
52,
My lords, I'm for the petitioner. My lords, the last rejection of the
State.
51.
52, who's appearing for the state? 52. You're appearing?
I'm not opening. Have you filed online or you have filed in our office?
No, you've given a file long back.
Lordship, I think it has not been allotted yet.
It's been
Running in.
running in the list.
Running in the list, no, but
Last
it has
two
not been allotted
circuits.
because we need to-
December 25, date of
December
filing.
2025. Lordship, we need to verify. Kindly
We are in
first report.
February.
Not today, Lordship.
Not today.
Report what happened? What?
next. 53,
53, Lord.
I'm for testimony.
Lord, the contraband is Lord 145 grams of brown sugar, which is intermediate, and Lord 48 bottles of cough syrup. And Lord, my first ground is on
So
the
as a whole, it's commercial.
yes,
Lord.
Lord.
Yes, whole commercial.
However, divided it is intermediate. Now, my Lord, my first ground is on the period of incarceration. The petitioner
long?
is in custody for 419 days, more than a year, my Lord.
Little more than a year. Yes.
And my Lord, I'll straight away take your lordship to the memo of arrest. It is, my Lord, at page 13 of my application.
Yes.
My Lord, page 13 of my application, column 2C. Page 13, 1-3. Column 2C, my Lord, notification of date and time of arrest. It is blank. Now, Lord, kindly takes note of, my Lord, the DK Basu's judgment and, my Lord, consequent insertion of section 41B in the CRPC, which is now, my Lord, section 36 of the DNSS. My Lord, may I read out section 36 and, my Lord, the relevant provision. Section 36 of the BNSS.
Yes.
Section 36 provides the mandatory procedure of arrest and duties of the officer making the arrest. It says every police officer, while making an arrest, I'm concerned with Milord C, 36C.
Yes.
Inform the person arrested unless the memorandum is attested by a member of his family, which is not the case here, that he has a right to have a relative or a friend or any other person named by him to be informed of his arrest. So, Milord, there is a gross violation of this particular provision, and Milord, in consonance of DK Basu's judgment, as well as Milord, a judgment passed by your lordship in the principal bench, Vishal Arya versus Union of India. Your lordship was pleased to vitiate the arrest and, Milord, grant bail to that petitioner. Now, Milord, my second point is on the grounds of arrest. Now, Milord, your lordship knows very well that the law regarding grounds of arrest has now crystallized in a very recent judgment of the Supreme Court in Mihir Rajesh Shah. I'm only, Milord, placing 2 paragraphs of Mihir Rajesh Shah. The first para that I'm seeking reliance is, my Lord, para 39 at page 17 of the judgment. In this case, my Lord, may I just place the facts? There is no grounds of arrest. The memo of arrest does not provide for any grounds of arrest. Neither is there a independent document which is a grounds of arrest. My Lord, para 39 it says, a plain reading of Article 22(1) of the Constitution of India shows that the intent of the constitution makers while incorporating the provisions was not to create any exceptional circumstances. Instead, it reads as, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of arrest for such arrest. It casts a mandatory unexceptional duty on the state to provide the arrested person with the grounds of such arrest, with the objective to enable that the person to be able to defend himself by consulting a legal practitioner of his choice. This mandate of Article 22(1) is notwithstanding any exception. This court has made it explicit that the constitutional obligation under Article 22 is not statute specific, and it is grounded in the fundamental right of life and personal liberty under Article 21 of the Constitution of India, therefore making it applicable to all offences, including those of under the IPC 1860. So, my lord, by this paragraph itself, I am able to rebut the presumption of section
So
37.
grounds of arrest was not communicated to you at
No,
all?
my lord. There is no document to that effect, no independent document, neither is there any reference in the memo of arrest.
That's all your submission?
My lord, para 56, para 55, my lord. Para 55, my lord, is a beautiful paragraph which provides the equitable remedy to the, my lord, investigating authorities. Para 55, my lord, at page 21. This is against me, but I am placing this paragraph. My lord. Para 55, it says, it goes without saying that if the above said schedule for supplying the grounds of arrest in writing is not adhered to, the arrest will be rendered illegal, entitling the release of the arrestee. On such release, here the remedy is provided. On such release, an application for remand or custody, if required, will be moved along with the reasons and the necessity for the same after the supply of the grounds of arrest in writing, setting forth the explanation for non-supply thereof within the above stipulated schedule. On receipt of such application, the magistrate shall decide the same expeditiously and preferably within a week of submission thereof by adhering to the principles of natural justice. So, my lord, the remedy is there before the investigating authority. At this moment, my lord, I have to be released. If they want my custody, they have to pray for a fresh remand in consonance with this particular paragraph. The next judgment, my lord, is Ashish Kakkar. It is a simple judgment, my lord. The principle underlying this judgment is that the memo of arrest is not grounds of arrest. My lord, para 5 of the judgment.
That's settled law by now.
Yes. So, my lord, these are my submissions in crux. I am praying for bail.
Yes, where is the grounds of arrest?
Lordship, before going into the grounds of arrest, my first humble submission before your Lordship is that 48 bottles of codeine phosphate and
He has not made any submission on merits. On merits, maybe it's a very bad case.
It's a very bad case. Lordship, he has relied on if I am not wrong, on Mehraj. Mehraj. In Mehraj, it has been clearly stated that regarding the arrestee has to be released immediately if there is no grounds of arrest henceforth. Henceforth means this case was the judgment of Mehraj came in the year 2025, and here the arrest was conducted on 19/12/2024. The Mehraj is the judgment of Mehraj is prospective, not retrospective.
Where does it say henceforth?
Henceforth, yes.
Where does it say?
Which para? Yes.
Lord Mihir Rajesh Shah discusses Vihan Kumar.
Yes, obviously, I admit.
Which are settled laws on the point of grounds of.
Vihan Kumar was discussed. Pravir Purakash was discussed. In Vihan Kumar also there was.
I do not find the word henceforth.
Yes, henceforth is there.
Henceforth is there.
Last year.
Lord, para 58. Para 58, if my lord sees, in the context that para 58 has been, we are cognizant that there existed no consistent or binding requirement mandating written communication of the grounds of arrest for all offences. Holding as above, in our view, would ensure implementation of the constitutional rights provided to an arrestee and as engrafted under Article 22 of the Constitution of India in an effective manner. Such clarity on obligation would avoid uncertainty in the administration of criminal justice. The ends of fairness and legal discipline therefore demand that this procedure, as affirmed above, shall govern arrests henceforth. It discusses the law.
Henceforth.
It discusses the law and provides henceforth direction. Doesn't set aside
and before,
the precedents of
before,
Vihan Kumar,
before
Pravir
production,
Purakash, Ashish
before
Kakkar.
Production, at least before 2 hours, grounds of arrest has to be supplied. This judgment is obviously binding upon us as per Article 141.
Have you supplied the grounds of arrest, sir? That is the only question which lies.
No. Grounds of arrest have not been supplied.
You cannot bypass this judgment at all.
I'm relying on
This is very
on
unfortunate that
only
even
one
in
expression.
2025, your IO doesn't realize that he has to give a this document to the petitioner. This is really very unfortunate.
And to be
We
frank,
have
and
Vihan Kumar, we have.
yeah,
earlier
absolutely,
judgments.
absolutely, Lordship. I admit, Vihan Kumar,
So you have-
Ashish Kakkar, Prabir Prakayasto, all have clearly stated the grounds of
Absolutely.
arrest have to be supplied.
And you have absolutely illiterate IOs, I should say, legally illiterate IOs, who really don't consider all this.
But Lordship, regarding DK Basu's judgment, the absence of the
2C.
signature, 2C, that will not dilute section 37 of the NDPS.
Even if I don't take care of 2C, what about the grounds of arrest?
Yes, grounds
There
of
is
arrest.
not a line. There should be something, even before the first remand, there should be something
Yes,
to
first remand.
enable him to defend himself.
Yes.
That's the whole
And
idea.
there is a distinction between grounds of arrest and information of arrest.
Absolutely.
Absolutely, there is.
So now that you have made your submissions on behalf of the court, I don't think anything further is required.
But my objection may kindly be noted.
This is very unfortunate. These are technical grounds where commercial quantity is recovered, but still the court cannot help. He's in custody for how long?
Well, 419 days.
The petitioner is in custody for more than 400 days and prays for bail, primarily on the ground that grounds of arrest have not been communicated to him at the time of his arrest. Learned paragraph, learned counsel for the petitioner places reliance on various judgments of the Honorable Supreme Court, including a recent judgment in criminal appeal number 2195 of 2025 with criminal appeal number 2189 of 2025 dekhe na, comma criminal appeal number 2190 of 2025 and SLP within bracket criminal number 8704 of 2025 dated 6th November 2025 in support of his contention. Learned counsel for the state vehemently opposes the prayer. Paragraph. It is a fact that contraband substance of more than commercial quantity has been recovered from the petitioner. However, the Honorable Supreme Court has in no uncertain terms observed that the constitutional obligation under Article 22 is not statute-specific, and it is grounded in fundamental right of life and personal liberty under Article 21 of the Constitution of India, therefore making it applicable to all offences, including those under the IPC 1860. The Honorable Court has directed has observed that in absence of supply of grounds of arrest to the arrestee, the arrest shall be rendered illegal, entitling release of the arrestee. Paragraph. In view of the above, this court is inclined to release the petitioner on bail solely on the touchstone of Article 21 and Article 22 within bracket 1 of the Constitution of India. Paragraph. Accordingly, the petitioner be released on bail on furnishing bond of rupees 20,000 with 2 sureties of like amount each, one of whom should be local, to the satisfaction of the learned. Which court is it?
My lord, special court NDPS.
The learned additional sessions judge, Siliguri,
Yes, my lord.
within bracket NDPS,
Sessions judge, second court.
Siliguri.
Not second court.
Second court.
Yes, my lord. Second court, special judge, NDPS.
comma, second court within bracket NDPS, Siliguri, subject to condition that he shall remain within the jurisdiction of the learned trial court. And shall furnish the address where he is not presently within the trial court jurisdiction, right?
Yes, my lord. He is a resident of the trial court jurisdiction.
Presently he is a
Yes,
resident.
ma'am. Yes.
Doesn't need to shift his residence.
No, ma'am.
And shall appear before the learned trial court on furnished laguna, and shall appear before the learned trial court on every date of hearing. Stop, he shall not tamper with evidence or intimidate witnesses in any manner whatsoever. Paragraph, in the event the petitioner fails to adhere to any of the conditions stated above, comma, the learned trial court shall be at liberty to cancel his bill in accordance with law without further reference to this court. Disposed of.
I'm so grateful.
Much. Next.
54. For the petition. My lord, in this case also confined myself on the ground, on the reason of ground. This is the copy of the memo of arrest. My lord, can you see? Only 21.5 kgs of gaja were recovered. And so far the memo of arrest is concerned, there has been clearly mentioned no ground of arrest has been defined during the course of arrest, neither in the memo of arrest nor independently after the 2 hours of the arrest. In this regard, my lord, under lawyer's lordship's kind attention, one observation passed by your lordship in the principal bench, particularly in the paragraph number 8, 9 and 10.
Monday's time because there are submission is on regarding the grounds of arrest. I don't have the case ID. Let me verify with the case.
Yes, whether
I
it
have
has
the
been
cert-
communicated to the
communicated or
petitioner.
not. 21 point some kilos have been seized. Charges have been filed.
Not today?
Yes.
Not today. No problem. Wait a favor. Please give it to me tomorrow.
I can hand over a copy to you. You know about it.
Next.
Did it.
He'll have it in his
55.
place.
For the state.
Item number 55, I'm praying for 1 day ago.
Not today. Please be ready tomorrow, madam. Next.
56.
56.
Lord, I'm praying for not today.
Not today.
57.
Madam, for the petition.
State. Yes.
May it please your lordships. Lordship, I am banking my submission on 2 points. First is regarding videography, and second is discrepancies in article seized allegedly and article sent before the FSL. Lordship, first of all, banking on the videography point, kindly comes to page 14, Lordship, for once. That is the last part of the written complaint, where second paragraph, last 2 lines. May I read it, Lordship? It is to be noted that the videography of search and seizure and labeling process was discontinued due to technical glitches on the video recording device. Now, whether this amounts to violation or not, Lordship, may I take your Lordship to one order passed in 2025. Kindly see his Lordship, para 5. It is for, may I read, Lordship? It is further stated that the mandatory videography of the seizure and search in the present case could not be completed by the arresting seizing officer as the recording instrument ran out of battery. So similar in our case, it was technical glitches and same thing, bail was granted. Now, Lordship, may I place another judgment order
Discounted due to technical
of
glitch.
coordinate bench, where basing upon Lordship knows better than me that this videography point, as envisaged in Kalu Sheikh's judgment by our division bench, which is a mandatory provision. Now I'll demonstrate, Lordship, whether at the bail stage this has to be considered or not. That we have that also. Lordship, here also the bail was granted for that the directions were given, even Lordship, bill was granted for this non-compliance of this videography point. Now, Lordship, I am giving trouble in another judgment of para 12, kindly see Lordship. Para 12, may I read Lordship? Considering the above, this court finds that issue raised by the petitioner with regard to videography at the time of seizure is a matter of trial. As regard the independent witness, it is not mandatory that every seizure has to be conducted in presence of independent witness. If the seizure is not made in presence of independent witness, it is also a matter of trial. So court decided that the videography is a matter of trial. Now this matter went before the Honorable Apex Court. The same point.
Inventory.
Lordship kindly sees what the Apex Court has stated in Rahul Rahman. Lordship, page 2, last paragraph, however, we are informed that the seizure of the contraband with 16,549 bottles of fanciful cough syrup was effected without video recording of such seizure. This was not in keeping with the directions of the High Court at Calcutta in its order dated 22/6/22 passed in CRM, that is Kalu Sheikh's order, Lordship. Kalu Sheikh, which required that such video recording should be made of the entire procedure in relation to the seizure of narcotics, and in the event of failure, reasons therefore were to be specified, recorded in the investigation record, and more particularly the contemporaneous document including seizure inventory list, the final order, dear Sajjan sir.
What is the stage of trial?
Lordship.
Now the last date was fixed on 5th of January 2026 for production and year of warrant.
Co-accused is absconding. Now, second point which I have to raise, if Lordship allows me, kindly see Lordship, the certificate of inventory page 35. What has been certified? Page 35. Got it, Lordship?
Yes, yes.
Lordship, from said packet, exhibit A is opened. Inside the packet, there was containing dead leaf and branch-like substance of gaja plant. Got it, Lordship? All the exhibits are same. Dead leaf and plant. Now, kindly, Lordship, sees
dried leaf.
Dried leaf and plant.
They are gaja.
Lordship. Now, neither the dried leaves or neither the stem of the plant comes under the purview of gaja as per section 2 of the NDPS Act. It has to be flowering top. If the flowering top, NDPS Goita, if the flowering
It's
top,
all dried leaf and branch.
branch,
everywhere.
all. Now, Lordship, there is a discrepancy, Lordship. Kindly see page 31. But first of all, Lordship, I'm giving a little trouble, Lordship, in the definition. May I read the definition, Lordship? Section 2,
Yes, yes.
subsection 3, cannabis, B, gaja. Got it, Lordship? Gaja, that is the flowering of fruiting tops of the cannabis plant, excluding the seeds and the leaves when not accompanied by the tops, by whatever name they may be called or designated. So, if the leaves and plant are there, the flowering top and fruiting, that portion has to be there. But the inventory says it is not there. But kindly see page 31, the FSL.
This is the flowering of the fruiting crops.
FSL.
The cannabis plant, excluding the seeds and leaves.
Kindly see page 31, FSL. Description containing parcel. What has been sent? Contain transparent zip-lock plastic packet in each. Each of the plastic packets contain green, brown color, dried and shaded vegetative flowering and fruiting materials appear to be branch of
So here it says flowering.
flowering. So there is a discrepancy. Now regarding this, Lordship, I may place an authority, Lordship, on this point. Kindly comes to Lordship, page, para 14. Para 14. May I read, Lordship?
Yes.
The Muddamal Mart P1 and P2 and P3 contain 15 kilo, and 13 kilo of greeny leafy substance purported to be gaja, which was seized, was produced before JMFC, and representative samples as per standing order were prepared from the bulk of Muddamal for analysis. Now, para 15, Lordship. The CA, that is chemical analysis report, was mentioned that the sample under reference has been tested positive for gaja. However, for the first time in the contrast of the greeny leafy substance which was found and seized, from which samples were drawn, a report of analysis referred to the sample which is in the form of soft greeny heterogeneous mixture, flowering and fruiting tops, bit of leaves, stem and stalk along with seeds of the plant, and this was tested positive for gaja. Now, para 16. The NDPS Act defined gaja under Lordship, we had already seen 2(3)(b). Now, relevant portion is para 17.
Yes, yes.
Para 17.
Yes, there's a difference between seizure and analysis.
Para 17.
I've seen that.
Lordship.
17 I've seen.
So, kindly, for my satisfaction, let me say the last paragraph. Strangely, the report of analysis referred to the sample which is heterogeneous mixture of flowering and fruity top, bit of leaves, stem and stalk, along with the seed plant. And the last 3 lines, the discrepancy in what was seized and what was analyzed prima facie satisfied me that there has been reasonable doubt for believing the appellant is not guilty of offense of dealing in commercial quantity, and in absence of any antecedent, he is not likely to commit any offense on bail. So this is the thing, Lordship. First point regarding the videography, it was not done.
And the discrepancy.
And
These
the
are your 2
discrepancy.
issues. Let the state respond to
In
this.
reply regarding the videography, it's already in the charge sheet, my lord. That
You cannot dispute.
regarding that, I don't have any dispute. I cannot dispute that. And thing is that regarding the what the magistrate has stated, that dried leaves and branch. So as per the section also, it's written the section says gaja, that is flowering of fruiting tufts of the cannabis plant, excluding the seeds and the leaf. But not the.
So this also you cannot dispute, I think.
My lord,
Yes.
my lord, that's true, my lord.
How do you dispute this?
No, that's true. But thing is that it has
So
to
if
be
that's true, we come to
now
the
flowering of the
resultant
fruiting
effect
tufts,
is.
my lord. But that generally we'll see the leaves. Leaves are also there, my lord. Here it is written as per the definition that the leaves are not
When
included.
accompanied by the flowering tops, Lordship, only leaves, when accompanied.
And the Supreme Court has stressed on that.
Yes,
My lord. But as per the FSL report, it has been simply gaja.
that is the thing.
What? How do they say that it is gaja when it doesn't fall within the definition? Again, you say that's true. Let me
These
pass
are
an
a matter
order.
of trial, my lord.
That also has been dealt with. The petitioner seeks bail primarily on 2-fold grounds. Stop. First, comma,
Yeah,
the seizure of the allegedly contraband substance has not been videographed. Stop. Second, comma, there is discrepancy between the substance seized and the substance analyzed. Learned counsel for the paragraph. Learned counsel for the petitioner has placed reliance on several authorities to indicate that under both the circumstances, comma, the petitioner is entitled to bail. Paragraph. Learned counsel for the state vehemently opposes the prayer. Paragraph. I have considered the material on record. Paragraph. The charge sheet this is the complaint, page 14.
Okay.
The complaint clearly indicates that videography of search, comma, seizure and labeling process was discontinued due to technical glitch of the video recording device. Stop. In other words, comma, the videography as mandated by this court in CRM within bracket NDPS bracket close number 492 of 2022 and CRM within bracket NDPS bracket close number 493 of 2022 has not been done. Paragraph. It appears from the description of articles seized and sent for analysis that the paper covers contained greenish brown colored, dried and shredded vegetative flowering and fruiting material appearing to be branch tops of plant bearing characteristic smell like that of cannabis. Stop. Strangely, the certificate issued by the magistrate under section 52 capital A within bracket 3 of the NDPS Act indicates that the packets sent for analysis contained dry leaf and branch-like substance, which were identified as ganja. Ganja, inverted comma, মধ্যে বা sentence, নতুন sentence. As defined in section 2 within bracket III, bracket closed B, small b, of the NDPS Act is the flowering of fruiting tops of the cannabis plant within bracket excluding the seeds and leaves when not accompanied by the tops, bracket closed, comma, by whatever name they may be known or designated. Stop. Paragraph. The substance which was analyzed doesn't fall within the definition of ganja as laid down in the statute. It is different from the one that was seized and sent for analysis.
Page number in it.
Paragraph. It is a fact that the petitioner has been accused of carrying contraband substance above commercial quantity. Stop. However, in view of the fact that the seizure was not
page number
videographed and also in view of the discrepancy between the articles seized and analyzed, this court is inclined to hold that such lapses shall such lapse is likely to affect the merits of the case. without going into the merits of the case at this stage,
No, the
comma,
grounds of arrest.
this court is inclined to
The only
release
independent
the
witness.
petitioner on bail on the grounds stated herein above.
What is-
Paragraph accordingly,
what is
preferable
the-
is allowed. The petitioner be released on bail on furnishing bond of rupees 10,000 with 20,000 with 2 sureties of like amount each. Petitioners, comma, one of whom should be local, comma, to the satisfaction of the learned additional sessions judge within bracket NDPS court, bracket closed, Kuch Bihar. They are residents of Kuch Bihar, subject to condition that they shall reside within the jurisdiction of the learned trial court and shall appear before the learned court on every date of hearing. Stop, they shall not tamper with evidence or intimidate witnesses in any manner whatsoever. Charge sheet submitted. Paragraph, in the event the petitioners fail to adhere to any of the conditions stated above, comma, the learned trial court shall be at liberty to cancel their bail in accordance with law without further reference to this court. Disposed of urgency information. Next.
58.
Section 2,
Our accommodation can have costs.
Yes, 58? Not today.
59.
Well, I'm for the state.
Hey, it is incomplete. Huh?
Petitioner, no one, not today.
Sixty.
Not today.
60, my lord, I am applying for the state.
61.
61, I'm for the state.
Yes, Monday. 61. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 16th February.
62.
61.
62.
Not today.
I am for the state, Lordship.
Not today.
63.
Not this week. Not today.
64.
Not today.
$65. 65 and 67.
Not today. Please be ready tomorrow, all these cases.
67.
Not today.
68.
I'm for the state university.
Not today.
I'm good.
69.
State.
Well, the petitioners are present, my lord, state, I don't have the CD, my lord, I'm not following this.
Not today. Please be ready tomorrow.
I'm ready. Ready, I'm the CD 19.
70.
Coincidence?
I'm for the
Not
state
today.
university.
Not today.
71.
Not this week. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 16th February.
72.
I'm for the petitioner.
State 72. No one, no objection.
No, my lord, Mr. Biswas will appear in this case, my lord.
Where?
Kindly make it 2 p.m., my lord.
2 p.m.
May I make one indulgence regarding item number 67?
67, you're ready? State?
67 again.
Only similar order can be granted for accused.
Give you a minute. Give me a minute. Who is there in 67? State? Please come back at 2 p.m. Please inform the state. Anyone in 67? State? Oh, you're a pin, yes. 67 again. Six 1 3. Yes.
7.719 kg Various person on the ground, and who are to be there, and be granted. I'm standing on the same sheet.
Yes, same footing,
My lord, Caesar list from, yes, my lord.
same footing.
Yes, same footing. I'll just show the Caesar list once for the clarification, my lord. Page number 35.
35,
Yes, ma'am. I'm just looking at the Caesar list.
30, 19.
Page 19.
Yes, my lord. Sadam Satar and Aditi. And
Same,
Aditya.
similarly placed.
Yes, my lord.
The petitioners seek parity with the co-accused who has been granted bail earlier. Paragraph, learned counsel for the state does not oppose the said fact. Paragraph, in view of the fact that the petitioners are similarly circumstanced with the co-accused who has been granted bail earlier, comma, they deserve the same benefit. Paragraph, accordingly, here it was 30,000, you took be, let it be the same.
Yes, lordship.
Since you are claiming parity, it should be parity
also
both
you
ways.
Submit the same amount of bail bond.
The petitioners be released on bail on furnishing bond of rupees 30,000 each with two sureties of like amount each, comma, one of whom should be local, comma, to the satisfaction of the learned, this is the special judge within bracket NDPS, comma, additional sessions judge, comma,
Additional, yes,
second
ma'am.
court, comma, Siliguri. Charge sheet
First-
submitted.
Charge sheet, my lord, it has been submitted, but the supplementary charge sheet is yet to be filed.
So let them appear
Yes, my
before
lord,
the trial court on
similar
every
conditions
date.
may be given, lordship. In the event the petitioner fails to comply
Let
with the
them appear
condition.
before the learned trial court on every date of hearing.
Yes, yes, yes.
May I, my lord? My lord, it is pending before the first court, Coach Bihar, my lord. Additional first court, Coach Bihar.
But this says special judge NDPS, second
my
court
lord.
Siliguri.
It may be, my lord.
Then how can you seek parity?
My lord, it may be, my
Yes.
lord, there is a wrong typographical error.
Did you ask for correction?
My lord, it is not my case, my lord.
My lord, in the cost title, they have given it additional citizen just
It is
first court,
Gokshadanga police station. My lord,
Coach
Gokshadanga
Bihar.
is under the Coach
Yes, my
Bihar
lord.
police station.
Gokshadanga
Whether
is
they have-
Coach Bihar.
Yes.
Koskosranga is Coach Bihar.
So there should be a
Similar
correction.
case, my lord, but
It is
in
not
this
my order, my lord.
Anyway,
order sheet, it has been wrongly, my lord, typographically. So they
Right,
need to
right.
modify it.
yes. I cannot modify some
No,
other
no, they need to
judge's
modify.
order.
They need to file an
It is
application
not,
for
he is
modification.
not the
It is
petitioner
not
here.
also my case. my lord.
Whoever is the petitioner has to do it.
Yes, my lord.
This is which court? Learned, court subject to satisfaction of the learned additional sessions judge, comma, first court, within bracket NDPS, Coach Bihar.
My lord.
First court within bracket NDPS, bracket closed, comma, Coach Bihar. Subject to condition that they shall appear before the learned trial court on every date of hearing and shall not tamper with evidence or intimidate witnesses in any manner whatsoever. Paragraph, in the event the petitioners fail to adhere to any of the conditions stated above, comma, the learned trial court shall be at liberty to cancel their bail in accordance with law without further reference to this court. Disposed of. Urgency reference. Next. 73.
73.
73, 74, 75, paying for next, not this week.
Next circuit.
Not this week. Not
Learned
tomorrow,
counsel.
all matter, tomorrow cannot be possible.
Yes.
And no, Monday. Next
Monday. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 16th February 2026. 73, 74, 75.
Month.
My lord, I beg of your pardon, your lordship. Lord, item number 70, my lord, can it be taken up, my lord? Your lordship.
It's difficult to go back
My
in
lord,
the
I
list.
beg of your pardon, your lordship.
You are appearing in
Mr.
70.
Bhattacharya is appearing.
Shurishna. Please try not to do
70,
this. It's
70.
difficult to go back.
Then tomorrow, my lord. Tomorrow.
70 ki not today করেছি?
Yes, my lord.
Let it come back to me. Because I have to do that in say all the matters in that case. Come back to me.
Lordship.
76. Should bring for one design. One design.
Please be ready tomorrow, not today.
77.
My lord, can it be fixed on 2 p.m., my lord? I have to go through.
You are not ready? Not today.
78,
Not today. Not today.
79,
Milord, I am for the petitioner, Milord.
Anyone 79? No one. State?
But I'm paying for not today, Milord. 1 day accommodation.
Not today. Come back tomorrow.
80,
80, I am appealing for the state.
80 petitioner?
For 1 day.
Not today.
81,
I'm paying for short pass over, Lord Sir.
Not possible.
I am appealing for the state, Milord. 81.
On 2 p.m. Lord Sir, kindly.
Will you come at 2 p.m.? 2 p.m.
81 to 2 p.m.
82,
82, my lord, praying for not today.
Not today.
83,
Not today.
84,
Not today. Not today.
85,
85 or 87, I'm paying for 1 day accommodation.
85
And 87.
You are in 85? Not today.
Grateful, Lord.
86.
86,
Hey.
86, my lord, fix on day after tomorrow, my lord.
Day after
My
tomorrow.
lord.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 13th February 2026.
Much obliged.
88, 87, not today you said. 87, anyone for the petitioner? You are appearing not today. 87, day after tomorrow. Learned counsel for the petitioner seeks accommodation. 87, Bashu. Let the matter appear under the same heading on 13th February 2026.
eighty-eight,
88, I am for the state.
Not today.
89,
My Lord, I'm for the petition. I'm praying for not today, my Lord.
Not today.
Not today.
90,
Lordship, I'm praying for 1 day accommodation.
Not today. Tomorrow I will not accommodate. Let me make it very clear. Next has to be
Nine.
disposed of.
91,
Not today.
92,
My lord, I am appearing.
Ready? 92 state. 92 state. No one.
2 p.m. Lordship, 2 p.m. Anuruddha আছে, Lordship, that Anuruddha, my lord.
2 p.m.
Yes, 2 p.m.
Come back at 2 p.m.
93,
Not today.
94,
Not today.
95,
95 and 97, case diary is not available, Milord. I am appealing both the cases.
Not today.
Not day after tomorrow. 95 and 97.
I do not find the petitioner. Come back
Milord,
tomorrow.
Milord,
Let me
Milord,
see.
Milord.
96.
96,
95, I would have prayed not today, my lord.
I made it not today.
Sorry, my lord.
I made it. It's
96,
Tomorrow, my lord.
not today.
Day after tomorrow, my lord.
96.
96 day after tomorrow, my lord.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 13th February. 96.
98,
Not today.
My lord, 96, I'm for the petitioner, my lord. I'm praying for
96.
Not today, my lord.
He's your senior.
My lord, I'm-
96. Someone has appeared on virtually
my lord,
and
maybe
asked for day
mistake,
after
but-
tomorrow. Come back. Let me see.
Good.
Yes, 98.
Praying for next week.
98.
98.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 16th February 2026.
99,
Not today.
100,
Case diary is not available.
Not today.
100. 96, 100.
101,
Not today.
102.
I'm praying for day after tomorrow, madam.
Petitioner.
Madam.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 13th February 2026.
103.
Not today.
104.
Not today.
105.
Lordship, 105, one indulgence. I have just received the certified copy of the evidences recorded. Can I do it tomorrow, Lordship?
Not today.
Grateful.
You are appealing?
One request from the state side. Lordship, they have only marked 100. After that, Lordship, what they have done is like they have marked from application for bail 155.
I need to call. Let me see the
Yes,
petitioner.
let
is there.
let it be called, Lordship. Will take time.
Let me call.
From tomorrow onwards, we'll just
But
fill
please
up
be
the
ready
yes,
from tomorrow.
we will fill up the list.
Yes,
Lordship.
please be ready from tomorrow.
Yes, yes, yes.
106.
Not today, Guru. Dekhe jain. Not today, Guru. Dekhe jain.
107. 108. 109.
108, kindly make it day after.
108. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 13th February 2026.
109.
Not today.
110.
Not today.
111.
Lord, I am of the petition. Madam, can it be fixed on 2 p.m., my lord? Madam, my brief is with my junior, madam.
Who is appearing for this? No, state is not ready. Let it be not today.
Or then day after
State
tomorrow.
doesn't have the.
Then, madam, day after tomorrow.
Day after. This is 111.
111, madam.
Bashu, 111. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 13th February 2026.
112.
Next week. Next week.
Next week. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 16th February 2026.
113.
Not today.
114.
Not today.
115.
On behalf of the petitioner, Lordship, this is an NDPS case, Lordship.
You're ready?
We are not prepared.
I'll just make it not to the state
we
is
are
not
not
ready.
prepared.
Great.
116. 117. 118. 119. 120. 121.
Lordship, I'm ready. Can I?
Not today because the state is not. You're ready?
Yeah,
You have to
ready.
be.
My lord,
the case ready.
2
Very
p.m.
good.
My lord.
2 p.m. So
Okay.
many man. Very good. Come back.
Very grateful.
122.
Not today.
123. 124. 125.
Your Lordship, item number 124 and 125, kindly fix it on Monday.
Monday.
Yes.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 16th February 2026.
Great.
124 and 125. Very well.
126.
Not today.
127.
Not today.
128.
Praying for not today, Your Lordship. 128, praying for not today.
128. Very well.
128.
Not today.
129. 130. 131. 132. 133. 134. 135.
And for the petitioner, Lordship.
In 135.
Lordship, yes, Lordship. I'm willing to do the matter, Lordship.
The state is not ready
We are
today.
not ready.
Not today.
Lordship, kindly make it in the top of the list for tomorrow's list because, Lordship, this is a very simple matter. This petitioner was already on bail. Thereafter, a warrant was issued. Thereafter, he was arrested.
He
And
has misused his liberty.
Lordship, actually, he was not informed about the upcoming date of appearance. Therefore, he failed to appear before the court.
Sudeshna, এটা একদম উপরে রাখুন তো কালকে। It'll appear at the top.
Grateful, Lordship.
Jump,
We'll be ready.
bail jump.
136.
Not today.
137.
Not today.
138.
My Lord, praying for not today, Lordship.
139. 140. 141.
My Lord, in 141, Lordship, I want to not press this application.
You want to not press 141. Learned counsel for the petitioner submits that the petitioner does not intend to proceed with the application any further. In paragraph, in view of the above, comma, the application is dismissed for non-prosecution at the certified website.
Grateful, Lordship.
142.
Not today.
143, 144,
Not today.
145, 146, 147, 148, 149, 150.
Lordship, I am for the petitioner. Lordship, on the ground of parity, I am praying for bail. Lordship,
The
this
state is not ready today. Come back tomorrow.
151, 152.
My lord, I'm for the petitioner. My lord,
One praying for PCN at 2 p.m.
151. You're praying for?
2 p.m. Lordship.
State is not ready to, I'll just make it not today.
জানি না দেখুন খালি আছে
He doesn't have the CD, not today.
One
my lord,
52.
152. 152, I'm for the petitioner, my lord. I'm 152.
State
I'm
is
for the
not ready, I'll
petitioner.
just make it not today. I'll make
My
it
lord,
not
my
today. State is not ready today.
But
153, 154,
You're appearing? Not today.
154.
Not today.
Application for CRM 70. CRM R 155.
দেবরাজ কোনটা সিডি নেই তো দেখো খালি আছে কি করবে খালি আছে দেখো না এখন এখানে আসবো
CRM R 70.
Yes, 155.
My lordship, I'm appearing for serial number 155. Waiting
Yes.
for advocate Sachin Tigde. Ma'am, day of tomorrow may be given as I'm holding for my counsel. Counsel is not available today.
You're asking for a not today. You're appearing in
not
155.
today, not today. Tomorrow they are top of the list. Lordship, actually they need to serve the victim also in this case.
They've not served?
They have not served. I have
Not
tried
served, but written.
What is the endorsement? Patient. Addressee left. So I'll request the state to serve, to inform.
Yes. Let them give a copy, that copy,
Yes.
so we'll hand over the victim.
Give this to the state, please. Huh. Since the petitioner is unable to effect service upon the de facto complainant, comma, learned counsel for the state is requested to effect service and submit a report on the adjourned date. Next Monday,
Next Monday.
let the matter appear under the same heading on 16th February 2026. Next.
156,
156, not today.
157,
My lords, I am for the petitioner.
You're ready?
Yes, my lords.
157,
Yes, ma'am.
state?
State ki hai one.
My lords, the service has been effected to the victim.
They've been affected.
Hmm?
They've been
Yes.
affected. So let's do it.
Where is the service?
Ek to diye den. My lords, the petitioner is in custody for 3 years, 10 months and 20 days. Evidence of the prosecutors is over. On most days, the witnesses are not coming. Therefore, there's a delay in trial of the trial. Furthermore, my lords, at the victim did not get examined, did not get herself examined
Before the
medical
doctor,
examination.
Yes.
And
Do you have the evidence?
yes, my lord. It's annexed. Well, the examination is at page 21, where the victim has refused to get examined.
No, the
Evidence.
deposition.
Yes, my lord.
You said that she has been examined in court.
Every exam. At page number 56. Page 56.
Give me a minute. I have to open this. Shudesh, mera khule de. Wait. Give me a minute, please.
My lord, my apology, at which she has not refused medical examination, but there was no evidence of forceful penetration. At page 56 is her evidence.
Shagur is the petitioner.
Yes.
Shagor is the petitioner, Lordship.
Sole accused.
The victim has been examined. This is the de facto complainant.
Yes, no, my lord, at page number 56 is the victim.
53 is the de facto complainant. 56 is the victim.
56. De facto complainant is daughter of the.
She has implicated the petitioner.
Yes, my lords. But my lords, it doesn't. My lords, there's at page 21, my lords. There, after careful medical examination, I have the opinion that there is no evidence of recent forceful penetration. Page 21, my lords.
আর নোটিং আছে।
She's the mother of the de facto complainant. So there may
Yes.
not be any medical is not that important, not very relevant in these cases. You're aware, right?
My lord, but there's no forceful and plus my lord's memo of arrest also.
She's in
There's
custody
no
for how long?
independent-
He's in custody for how long?
3 years, 10 months, and 20 days.
Stage of trial?
My lord, evidence is ongoing.
How
Out
many
of
witnesses
18
are left?
After 18, about 10 witnesses are left, my lords. Out of 18, about 10 witnesses are left.
Out of 18, 10 are left. 8 are examined.
Yes, my lord.
Let me hear the state. Yes.
Also, my lords, one more thing. My lords, there's no independent witness at the time of arrest of the petitioner. And Muslim, my lords, no clothes of the victim has been seized. These kind of things are also there, which are.
Let me hear the state.
My lord, in the 164 statement, she has stated that during the holy day, my lord, this Sagar Loar, who is the neighbor, he entered inside the house of the victim, lordship, and he tried to rape her.
Tried to?
No, lordship, not tried to. मेरे साथ बुरा काम किया. So he raped her, according to her 164, and the medical legal statement was collected, lordship.
Yes, the medical legal.
Medical report is not annexed, my lord, actually. It was collected and it was sent. And my lord, further, my lord, what has happened is like, it was sent to the doctor. After that, my lord, the medical swab was taken, but the medical report is, I'm not finding in the CD, my lord. I'm just checking. You just give me 2 minutes, my lord.
You have the medical report
Page
with you?
21.
It's 21.
Page 20. In my petition.
Submitted, actually, this time.
To the date of claim.
Nothing to the person project. Nothing to the.
Let him face trial. Let him remain outside jurisdiction.
Yes, yes, yes.
Great payments.
My lord, the medical is not annexed with the certified copy because it was taken back for the evidence.
Right,
That is why.
it's
Yes.
part of the
Yeah, part of
record.
the- yes, yes.
The petitioner is in custody for more than 3 years and prays for bail. Learned counsel for the petitioner submits that the petitioner has been falsely implicated. The medical report of the victim does not demonstrate any recent forceful penetration. Paragraph, learned counsel for the state opposes the prayer. Paragraph. It appears that the de facto complainant and the victim have been examined. 8 out of 18 are examined, you said, right? 8 out of 18 witnesses are examined. Stop. Trial will take some time to conclude. Paragraph, considering the period of detention of the petitioner as well as the fact that the victim and the de facto complainant have been examined, comma, this court is inclined to release the petitioner on bail subject to stringent conditions. Paragraph, accordingly, prayer for bail is allowed. The petitioner will be released on bail on furnishing bond of rupees 10,000 with 2 sureties of like amount at 10,000. With 2 sureties of like amount each, comma, one of whom should be local, comma, to the satisfaction of the learned additional district and sessions judge, comma, fast track court, comma, Siliguri, subject to condition that he shall remain outside the jurisdiction of. The victim is a lady of which place? Nishchintapur. PS Matigara.
Yes, my lord.
He'll remain outside Matigara.
Yes, my lord.
Outside the jurisdiction of Matigara police station and shall furnish the address where he shall presently reside before the learned trial court, comma, the investigating officer and the officer in charge of the police station under whose jurisdiction he shall presently reside. Stop. He shall appear before the learned trial court on every date of hearing and shall not tamper with evidence or intimidate witnesses in any manner whatsoever. Paragraph, in the event the petitioner fails to adhere to any of the conditions stated above, comma, the learned trial court shall be at liberty to cancel his bail in accordance with law without further reference to this court. CRM disposed of, as I said, fellows. We'll continue at 2 p.m.
Morning like this. One matter is back on PM. Can it be taken up at 3 p.m.? I have another matter. Good number.
Item number?
92.
Here for the state?
And for the beach.
Item number 92.
92.
Very well, 3 p.m. 92 to 3 p.m.
Yes, sir.